decision because that happens in one moment. You live.
Good morning. Good morning. Good morning. Can you hear me?
Good morning, Daktari.
So today I intend that today be the last class and that we cover the last topic or topics. I think we have covered enough grounds over the last 1 year. We have done judicial review. We've spoken about an application for habeas corpus. You have done it also in the project. Sorry, did you receive your project work? All of you? Have you received your project results? Have you received your project work results?
Yes.
Everyone? Okay, so we've covered all these topics that I can see here. The last presentations were on private prosecutions and inquests, and then I think there are 2 firms that presented. I think those are some of the things that are remaining. We've covered appeals, judicial review, revision, and all these other things. What is left today is something that we can say on extradition. So something I can say briefly about extradition. So there are 2 acts of parliament. There's Extradition Commonwealth Countries Act and Extradition Contiguous and Foreign Countries Act, both of which outlines the legal framework for the surrender. So extradition is basically the surrender of a fugitive, from Kenya to other countries. How do you surrender a person who is required to face trial in another country, trial for an offense committed in another country? Now, extradition, of course, is different from extraordinary rendition or deportation, legally or colloquially speaking. Extradition is a legal process, is a legal judicial process preceding or including the arrest, the hearing of the case, the termination of the case, and the issuance of warrants of surrender of a fugitive or a person who's required to face trial in another country. Deportation, of course, is not a legal process, it's not legally sanctioned. It is done through the immigration officials or processes of a country, as well as rendition, which of course is the legal arrest, the extrajudicial process. Both rendition and deportation are extrajudicial processes that are different from extradition. So as I've said, the process generally involves a formal request for surrender from a foreign country, the issuance of an arrest warrant by the court. The arrest warrant is issued by the court, and then a person is arrested and brought before the court, a magistrate court. It's a magistrate's court, remember, and a hearing takes place before the magistrate's court to determine the lawfulness of the request. So here you'll be talking about extraditable offenses, and as well as the law on restrictions on surrender. So the magistrate court will determine the lawfulness of this request and the potential surrender to the requesting country. And then certain key conditions for extradition must be met. So we'll be talking about those key key factors or key conditions that one must meet before a person is extradited. So extradition is a simple process. It's a simple judicial process. I don't think you should not detain us here. What will happen is a foreign country who wants a person prosecuted in that country, whether that person is a citizen, has committed an offense in that country, will make a formal request to Kenya, the receiving country. So that country is called the requesting country. Each person so and so because he has committed this and that offense in our country. And then there must be proof. So we look at the proof. What are the things that must accompany such a request? But then there is a law that must be satisfied. There is the formal requirement under the Extradition Act. First of all, is the requirement under Section 4 of what they call the extraditable offenses. Extraditable offenses. For a country to surrender a fugitive, the Commonwealth Act, the Extradition Act provide a raft of requirements. First of all, there must be a designated Commonwealth country under Section 3. So if you're going to extradite under the Extradition Commonwealth Act, such a country must be a designated country under the Act. That's Section 3 requirement. Second thing is what we call the extraditable offenses. The extraditable offenses are recognized by law of a requesting country and punishable by imprisonment for a term of more than 12 months. And such an offense must be an offense in Kenya or recognized by the law in Kenya. And of course, you go to the fourth schedule, you'll require them. So it must be an extraditable offense. So extradition will be granted only if the conduct for which the person is sought constitutes an offense under the laws of both Kenya and the requesting country. Some call it extraditable offense under Section 4. Some call it double or dual criminality. Double or dual criminality. That is to say that if you're going to seek any other country, say, for instance, the US, wants to extradite a person for an offense. In the US, they call it homicide. In Kenya, we call it murder or aggravated injury, whatever the case. It must be an offense recognized in Kenya. If it is not recognized in Kenya, then such a person cannot be extradited to such a country. The second requirement, of course, is that there are certain conditions. There are certain conditions that will limit or will preclude extradition. So under Section 6(1), so we have said the first thing is dual criminality. The other one is that the person must not be accused of an offense of a political character under Section 6(1). So that is the second requirement. The offense must not be of a political character, or it should not be a political offense. So extradition will not be granted for offenses of a political character, where somebody sought to be politically assassinated, where a person is sought maybe because of his shade of opinion or political association. The other requirement, again under Section 6(1)(b), is that a person will not be extradited or extradition will not be granted if the request made is for purposes of prosecuting on account of race, religion, or political opinion. So apart from political offense, we are talking about race, religion, or political opinion, or nationality, race, religion, nationality, and any other shades of opinion. Again, the Act also provides that the fugitive may not be tried by reason of race, religion, nationality, or political opinion. Section 6(1)(c) and 6(1)(b) are similar. Now, so those are the conditions that may preclude the granting of extradition proceedings. You have said for somebody to be extradited to another country, there must be dual criminality. That means the offense must be recognized in Kenyan law and in that country. A person must not be prosecuted for political offenses. Neither should he be prosecuted by reason of race, religion. In such circumstances, the court may refuse to grant extradition proceedings. Now, what is the procedure? Again, under Section 5, the law provides that where a fugitive can be arrested, he can be detained, and it can be surrendered that in the manner prescribed by the Act. Again, the High Court has a role. The High Court has a role here again, as we will see, the role of habeas corpus before a person is surrendered. Now, in terms of procedure, and I think here we are talking about the process now from point A to point B. How do you move where a request for surrender has been granted? So by practice, the Foreign Affairs Ministry of a foreign country will make a formal request for surrender. Those documents will be taken to the Foreign Affairs Ministry of Kenya, because we are dealing with international relations here. When a document comes from the United Kingdom, it will be submitted by their Foreign Affairs Ministry, the request for surrender, arrest and surrender of a person. It will be taken to our Foreign Affairs Ministry. The Foreign Affairs Ministry, of course, will forward it to the Attorney General, because these are legal issues. These are legal issues where they need some sort of legal advice. Now, once presented to the Attorney General again will transmit those documents to the Office of the Director of Public Prosecution. Because extradition belongs in the criminal realm and the Supreme Court has held so, this is the mandate of the DPP. Now, once the DPP receives the formal request for surrender from the Attorney General's office, he will prepare what is called an authority to proceed. So an authority to proceed is a fundamental requirement under Section 7(1) of the Act, the Extradition Act. So there must be an authority to proceed issued by the DPP before dealing with or arresting a fugitive. When the request is received, the person is not arrested. So arrest can only come with a formal warrant of arrest from the court. Now, the DPP will prepare an authority to proceed. That authority to proceed will be taken before the magistrate's court. Now, it is not only the authority to proceed that is taken before the magistrate's court. Other documents must as well accompany that authority to proceed. One of them under Section 7(3). So we are talking about the formal process. We have said once the request is received from the Attorney General, the DPP prepares an authority to proceed. An authority to proceed is accompanied by the following. One, there must be indication that a warrant has been issued by the overseas country. So an overseas warrant issued by the requesting country. So the formal request will be received by the DPP. The DPP will prepare an authority to proceed. But in the authority to proceed, before you forward them to the magistrate's court, it must be accompanied by a warrant issued in the requesting country, so there should be a warrant. In the case where there has been a conviction or a sentence of that person in the foreign country, a certificate of conviction or sentence in the case of a convicted fugitive. Now, there must be what is called a statement of the offense. In our country, we call them charges. So the warrant of arrest, if the person has been convicted, any document of proof of conviction and sentence, and the statement of the offense. If it's a Commonwealth country, you expect to see formal charges drafted. So statement of the offense which has been served, which has been served or the person has been accused of. The particulars of the fugitive, it must contain his identification, passport numbers, where applicable, birth certificate, all indications of the particular that identifies the fugitive or the person that is sought to be arrested and surrendered. Now, here they're talking about the other thing is the facts upon which the accusations have been made and the law under which he is accused or was convicted. Here again, you can look for the formal documents of charges, if there's a judgment, or the requesting country can indicate that we are requesting this person because he's accused of having committed offense so and so under their law. So they must state under what law, what offense, and the particulars of those offenses That is, the requesting country must give as sufficient details as possible. The reason is this: even the DPP, before making the authority to proceed, must ascertain that our law has been satisfied. Similarly, the magistrate, which will conduct the hearing, because we have said before a warrant of arrest is issued, the warrant of arrest will only be issued upon considering and determining the information that justifies the surrender of a person. Part of it is that the magistrate must be satisfied that the particulars would be sufficient enough to sustain a conviction in Kenya for the relevant offense that has been charged. So the magistrate will hold a hearing to determine the lawfulness of the extradition request. That's why particulars and sufficient details are important. So the facts upon which the accusations are made, the law under which the person is accused, or under which he was convicted. Now, the act also talks about evidence sufficient to justify the issue of a warrant of arrest. Here, we are talking about evidence. So, other than the formal charges in that country, other than a warrant of arrest issued in that country, or a certificate of conviction or sentence in that country, and the particulars and the charges, you are required, if at all it comes in the exam, to prepare that evidence. Evidence here, we are talking about the documentary evidence, videographic evidence, expert opinion evidence, or any other form of evidence. The court will have to look at that. So, accompanying the authority to proceed must be sufficient evidence to justify the issue of a warrant of arrest. So the DPP will issue an authority to proceed upon request being made by the requesting country and accompanied by the above documents. Otherwise, the warrant of surrender shall not issue under the Act. Section 7(3) of the Act is very, very clear. If these documents are not present, the warrant of arrest and surrender shall not issue. Now, upon receipt of authority to proceed by a magistrate, together with all the documents that we have talked about, the sufficient evidence and all that, the warrant of arrest shall be issued by the magistrate. So you should by now know how a warrant of arrest looks like. Now, once the person is arrested, he is then brought before the court. So the purpose of the arrest is not to arrest the person and put him on the next plane and extradite him or transfer him to another country. No, the purpose of the warrant of arrest is to have the person presented before the court. So once the person is presented before the court, then you call them committal proceedings. You call them committal proceedings under Section 9. So proceedings for committal once a person is arrested. A person arrested under Section 9(1) is to be brought as soon as possible before the court. And of course, here what will be happening is a trial like any other. Evidence is given, the authority to proceed is presented, the allegations of the criminal offense in that country is presented, the sufficient evidence is presented, and the person has all other rights like in any other trial. The fugitive has all other rights like in any other trial. So this is a formal trial process. And during the trial process, the court has got the powers to commit the fugitive to custody pending the hearing or surrender. Now, in such a case, the court will only commit the fugitive to custody if it has received the authority to proceed, if it is satisfied. For example, if it's going to commit the person to surrender, if it is satisfied after the hearing of any evidence tendered in support of the request for the surrender, the court must be satisfied that the offense to which the authority to proceed relates is an extradition offense. So he must satisfy all the criteria that we have said under Section 4 and Section 6. Dual criminality must not be a political offense, and the person is not sought to be prosecuted for political offenses or on the basis of race, religion, or nationality. Or the person is not being sought twice. The principle of double jeopardy also applies. So it's one of the grounds upon which extradition may be precluded. Now, the other thing that the court must be satisfied, again, under the Act Section 95, is that the fugitive is accused of the offense and that the evidence would be sufficient to warrant his trial for that offense if it had been committed in Kenya. So this formal hearing process is for the court to satisfy itself of the requirements of the law, but also to ensure that there is no triviality, that the offense for which he is accused are trivial or are non-offenses in Kenya or another country. Now, under Section 10, if a person has been committed to custody pending hearing, okay? So if the court issues warrants of surrender, there must be 15 days from the time the court issues warrants of surrender of the person. There must be 15 days during which there should be no surrender. No, so under Section 10.2, a fugitive not to be surrendered until after 15 days of the order of committal to custody or to surrender. Now, what is the purpose of the 15 days? Can somebody tell us why is the period of 15 days so important? The 15-day period. Yes, Juma.
Maybe to enable the fugitive to apply for a writ and the directions to apply for a habeas corpus order.
Yes, to apply for habeas corpus orders, purposely maybe to appeal the decision to the High Court. It is because extradition has a great impact on the fugitive or on the accused person in another country. Remember, you're taking a foreigner or a Kenyan citizen to be tried for an offense in a foreign country. So the procedure, the requirement of 15 days is to ensure that at least the magistrate's court did not err in law or in fact. So under Section 10, one can apply for what is called a writ of habeas corpus. So a fugitive shall not be committed to custody pending surrender, must be informed of his right to habeas corpus. So the person once committed to surrender and to custody pending surrender, there must be a 15-day period, and that person must be informed of his right to habeas corpus. Under Section 10.2, if the person files an application for habeas, yes, Muturi Cosmos?
Mwalimu, I have a question. This habeas corpus that we're talking about, when we are looking at the other habeas corpus now, we are talking of a person that has been, we suspect that was arrested by the police, but has not been produced before court. Now here you are talking of a person that has been produced before court. So how does it arise that we are making this application?
Yes, that is how the Act, of course, that is how the Act calls it. Okay, the Act calls it an application for habeas corpus under Section 10. But ordinarily, in my view, I think it should be an appeal. It should be an appeal process. So that's what I don't know why the Act was imported from another jurisdiction, but ordinarily it should be an appeal before the High Court. The Act calls it an application for habeas corpus. Because if you look at Section 10.2b, it says no surrender as long as proceedings for habeas corpus are pending before the High Court. Okay, so you will draft an ordinary habeas corpus application for the person to be produced before the High Court. So if an application for habeas corpus is made in this case, so long as proceedings on that application are pending, a fugitive is not supposed to be surrendered. So essentially, an application for habeas corpus will act as stay of the warrant of surrender. And of course, the High Court has got several powers. The High Court can order a discharge of the fugitive in certain circumstances. One, if the offense is of a trivial nature, that is section 10.3, and if the court consider that a reasonable amount of time has passed since the person committed the offense, the person can also, the High Court can also order a discharge. Or if the application for extradition is not made in good faith, you look at section 10.3 provides for that. But the High Court can also call for additional evidence in such circumstances. But again, if there is no contrary decision from the High Court, the DPP may issue warrant of surrender where a person has been committed to wait surrender to the requesting state and where there is no contrary order of the High Court. If you look at section, that is all about extradition. So in terms of procedure, authority to proceed, there must be a formal request from another country, which is called the requesting country, which is a formal document presented to the DPP. The DPP issues authority to proceed. The authority to proceed is accompanied by many documents, the formal charges from that country, the warrant or arrest from that country, sufficient evidence from that country, or all relevant documentary material from that country, and perhaps an explanation. That will be presented before the magistrate court, who will issue a warrant of arrest. The person will be arrested, brought before the court. There will be a formal hearing. After the hearing, if the extradition is satisfied, then there's a 15-day period within which the person is not supposed to be extradited. He can appeal to the High Court by way of the habeas corpus application. If the High Court application is successful, the High Court can discharge those orders of the magistrate court. If not, the person shall be surrendered. The warrant of surrender shall issue from the DPP's office. Any question on that? So, yes, Cosmos.
Yes, Mwali. Okay. There are some countries that are very reluctant to extradite their citizens. One of them being the US. And now that you are talking about dual criminality, because okay, for the US, you hear them saying that they want to try their citizens. So do they request for that evidence from the country where that person committed the offense to be brought to the US so that they can try their citizen there, or how is it done?
Sorry, I didn't get something. I missed something from you.
Okay, what I'm saying is that some countries are very reluctant to extradite their citizens, one of them being the US.
Yeah.
And what they usually see is that they want to try their own citizens. So now that you are talking about this, the dual criminality element, does it now mean that they will request for evidence of the offense that the fugitive is being accused of having committed to be brought to the US so that they can try their citizen there, or how is that done?
Yeah, there is also the political aspect of all these legal processes. One of the things is that Kenya has always been very, very quick to extradite even its own citizens where a formal request has been made by the US. In fact, Kenya has also been complicit to extraordinary rendition. You remember the Turkish cases, who were abducted and deported to their own country, yet they were refugees in this country. There have been the case of the Akashas, who were arrested while the extradition proceedings actually were pending before the court. Their abduction and rendition was announced when the plane to the US was mid-air. Now, I don't think, as you say, the US will not be able to do that where its citizens are involved. In fact, Kenya has done this where its own citizens are involved. So these are political decisions. They're not necessarily diplomatic, but they're informed by certain choices. The relationship between the US, where the levers of power, it does not favor us. Maybe somebody just calls the Minister of Interior or Kenya Foreign Affairs Minister and put pressure on them so that these persons are unlawfully and extrajudicially taken out of the country. The US will not be able to do that. But I think also their law will be more applicable. Perhaps they have a provision of their law that says that a person can be, tried for those offenses. But in a case where Kenya makes a request for surrender of a person for trial before the country, I don't think the US law will be applicable, because in the United States, they have a principle called the non-extraterritoriality of a law. So if the person committed the offense in Kenya and Kenya seeks the surrender of such a person, I do not think the US will have any justifiable cause or reason to try that person in their own country, in their own jurisdiction, if the offense was not committed in their own jurisdiction. There should be no reason at all, except for political considerations, political considerations. Or if the person goes through the formal judicial, the law in the US is very, very strong. So they may be able to put up a strong case, for instance, that if they come to Kenya, they will be discriminated on the basis of race. Or they may say that, if they come back to Kenya, this can be considered a political offense. Or in certain cases, where certain offenses are punishable by death in Kenya, but in certain jurisdiction in the United States, such an offense there is no death penalty. Such a person can also challenge such extradition process. I know in the UK, there's a case called Soaring versus the United Kingdom, where the person actually was successful in challenging his extradition to the United States because of the potential of facing a death penalty. Yet death penalty is unlawful in the United Kingdom or in the EU generally. So if one can bring legal arguments that maybe the offense, because the offense may be having different names. What may be called murder in Kenya may be different from what they call homicide in the US, or degrees. So one can actually make an argument that, look, there is no dual criminality for this offense because Kenya does not recognize an offense of whatever degree. One can bring any legal arguments. Any other question? Yes, Charles?
Morning, sir. My question is in relation to what was asked earlier. So if there is 2 requests from separate countries, let's say America and Nigeria, how do we approach that? And the Nigeria one was made first, and then the USA one was second. So how do we approach that? And then I also have second question. The process we've discussed is out of Kenya, extradition out of Kenya. So is it the same process for extradition into Kenya when Kenya is the requesting state? Thank you.
Okay, those are two good questions. Yeah, but that's the scenario one is possible where a person is sought to be tried in 2 different countries, maybe for the same offense. For example, drug trafficking. That's a complex one. That's a complicated one. Wouldn't the discretion then be on the DPP to decide where to issue warrant of surrender to? I should think so. I mean, I've never come across such a scenario where a person is sought to be tried in 2 different jurisdictions, and one comes first. So the discretion is on who? Is it the court or is it on the DPP? I think because the extradition process, the committal proceedings, is just a confirmation. It's just a confirmation process. Ideally, it's the DPP who has the authority to decide where this person is to be extradited, because at times the DPP can also refuse to issue authority to proceed. He has that power. He can receive the formal request from that country. He can sit on it. If, for instance, he feels that he may, in his own feeling, suggest that there's no extraditable offense, one, there's no double criminality, or the evidence is not sufficient, he may decline. Similarly, that power, because he has that vast power, can also be applied in selecting a country where a person is sought to be tried in 2 jurisdictions. In my view, I've never come across such a scenario, unless somebody has a different opinion, a contrary opinion. Is my opinion correct? I should think that's how the DPP, yes, Thomas?
I also join you in the same opinion. And I will just say that it also relies on the diplomatic ties that Kenya has with those two countries.
Yes.
It may decide to favor one over the other and proceed with one outside the other.
Yeah. Should think so. Priscilla, different opinion?
Okay, good morning.
Morning.
Mine is not an opinion, it's like kind of a further question. Like, what if in this scenario of Nigeria and USA, Nigeria has already commenced the, what do you call them? Has already commenced the proceedings. Like, can you like prefer Nigeria because it's already prosecuting this person?
Again, look, we have talked about two scenarios here, where a warrant of arrest has been issued in a foreign country for the person to be surrendered or extradited to that country to commence trial. There can also be scenario where trial has already commenced and is ongoing in the absence of the fugitive. Scenario 3 can also be the person has also been convicted in his absence. There are so many scenarios. In fact, I was hearing one where the former president of the DRC was convicted, I don't know whether it was rumors, to death in his own absence. So those three possible scenarios, I don't think they are material or they are having a determining effect on a country where somebody is supposed to be extradited to, where there are two requests. I should not think so. Yeah, so it doesn't really matter that in country A, the process has not commenced, while in country B, the process has commenced. I think the DPP will have to apply its discretion. And if anything, I think the warrants of surrender, because they're issued by the DPP, once the committal proceedings has confirmed, it can also issue to both countries. Then the extradition process now depends on them. You know, yes, because the extradition process now, the person has to be picked and transferred to that country. So it's upon which country who comes first. It's a complex scenario. So that would be my answer. What was question 2? Question 2 was, does the extradition process apply to extraditing a person from Kenya to another country? Yes. Now, where Kenya makes a formal request to a third country to surrender a fugitive into Kenya, Kenyan law will not govern that proceeding or that procedure. It is the law of the requested country that will apply. Remember, all law is national. Municipal law is municipal law. Municipal law of a country cannot apply in another country. I think the US is very right with their principle of non-extraterritoriality of law. Law is territorial. It only applies within the territory and the jurisdiction of that particular country. Kenyan law cannot apply into Uganda. If, for example, Kenya makes a request for extradition of a person X, whether that person X is a Ugandan citizen or a Kenyan citizen, Kenyan law shall not apply. It is the Ugandan law that will apply. And I believe it's a Commonwealth country. They have a similar law like our Commonwealth Act with designated countries. Any other question? There is what the syllabus calls special. Irene?
What if a request is made and the receiving country does not make any action on the same?
It becomes an international relations issue. It becomes an international diplomatic issue, which can now be tackled at a different level by the Foreign Affairs Ministry. But you can be sure there is no way you compare that country going in the international court. You know, international law is also based on state consent and Committee of Nations. Like right now, it is said that Uganda, 2 Kenyans have been abducted and disappeared in Uganda. And really, there is really nothing Kenya can do except through diplomatic channels. Nelvin?
It's just a question. I was wondering, after arrest, is a fugitive entitled to bail?
Wow, that's a good one. That's a good one. But wouldn't the granting of bail defeat the purpose of the arrest? Take the scenario of a Kenyan citizen who murdered his girlfriend, called his girlfriend to his house. I think they quarreled, they disagreed, murdered her, wrapped her in a blanket, put her in his car, and drove all the way, I think, to Chicago International Airport, dumped the car at the basement of the airport, took the next flight to Kenya, and joined relatives and was enjoying himself here. It was only weeks later that they discovered a decomposing body. The US made a request for the surrender and extradition of such a person. He was arrested, placed in police custody, disappeared, escaped from police custody. Now, while the proceedings were going on, imagine such a scenario where you grant that person bail pending the hearing of his, pending the committal proceedings. I think it would defeat the purpose. I've never seen a situation where a person has been admitted to bail. Particularly if that fugitive who has escaped from another country. The situation would be completely different for the information if the person is a citizen of Kenya, resident in Kenya, and who has not been transferred.
Okay, thank you, Mwalimu. I was having another question. In the issue of ICC criminals being surrendered to ICC, let's say from Kenya, I was reading Section 30 of the International Crimes Act, and the first court of competent jurisdiction is the High Court. So I was wondering, given the scenario, when you want to apply for the writ of habeas corpus, does it mean you will apply to the Court of Appeal directly?
Wait, I think I've lost something. Wait a minute. What is the question again?
Okay. When you are surrendering ICC criminals or suspects to ICC from Kenya, Section 30 of the International Crimes Act provides that the High Court is the one to issue warrant of arrest, and the suspect is to be brought before High Court before they are surrendered to the ICC. And I was wondering, given the fact that they are entitled to the writ of habeas corpus, does it mean when you're making an application for the writ of habeas corpus under such circumstances, you will make it to the Court of Appeal?
I don't think so. Honestly, I do not think so. I'm not quite keenly read the International Crimes Act, but I think it should be able to replicate the Rome Statute. Remember, the High Court has got original jurisdiction in all civil and criminal matters. So where a person is sought to be extradited for purposes of prosecution for international crimes, I think at the High Court you can apply for bail. It will not be called a writ of habeas corpus in this particular situation. The High Court, you can apply for bail pending the trial, because the High Court has to make a determination, by the way, before issuing warrants of arrest. So you can make an application for bail pending the hearing of that whole application. The procedure is actually different from extradition. You know, this is extradition for purposes of prosecution in another country. That's why there's a specific act. This is Extradition Act, and then there's a International Crimes Act. I believe the procedure is probably certainly different if you look at the rules under that act.
Thank you.
Is that satisfactory? Yes. There are certain special procedures here that the syllabus wants us to talk about. For example, procedures relating to freezing of accounts, search and confiscation, and so forth. Now, you know, there's just like the example you have given, regimes are different. There can be two different regimes. So here we're talking about the extradition regime, and we're talking about the international crimes regime. Those are different. Similarly, where you talk about confiscation, asset seizure, freezing of accounts, asset recovery, and so forth, those are different regimes from a criminal trial process. Now, there are two possible scenarios where one can seek forfeiture of assets, seizure of assets, one can seek asset confiscation or freezing of accounts or non-transfer of assets. One scenario is if Juma Thomas is being prosecuted or is facing a trial for corruption or economic crimes before a magistrate's court. So he's accused of having, embezzled funds from a government institution, and he has bought 6 Range Rovers and he has 10 apartments in Rwanda and so forth. But then the prosecution feels, the DPP feels that, he may transfer these properties or he may sell them, or the cars may be transferred to third parties, therefore defeating the purpose of prosecution. In such a case, the DPP can apply for orders restraining any transfer or sale of such assets, or the freezing of an account. The most important thing you are asking yourself there is, what is the procedure to be followed? You make an application by way of notice of motion application to that very, very court to grant orders, conservatory orders, whether injunction, whatever you may call them, Anton Pillar or Mareva injunction, whatever you may want to call it, as applicable, to stop the transfer or sale of assets or money. Yes, Maina, before I proceed. So that's scenario 1. Yes, Maina, ask your query or forever maintain your peace.
Sorry to take. Sorry to take you back, and I hope you can hear me. My question is on a jurisdictional issue. So, given the scenario that you've just given us of murder, we know that the High Court is the court which has the exclusive jurisdiction to determine issues relating to that particular offense. So, and as per our reading of the Act, it appears that you are supposed to first go to the magistrate courts. So how do you reconcile that jurisdictional issue in the magistrate courts issuing the warrant of arrest and proceeding with the committal proceedings when they do not have the jurisdiction in Kenyan law with respect to that specific offense?
The offense of murder?
Yeah.
So you're asking if somebody is sought to be extradited for the offense of murder to another jurisdiction? Is that a question?
Yes.
Okay.
And, yeah.
I think really the subject matter jurisdiction shouldn't apply to extradition proceedings. What should matter is the principle, the consideration of the principle of dual criminality. Whether, in fact, the law is very, very clear, whether that constitutes an offense in Kenya and in a foreign country. That is the principal consideration. That is the determining factor. The nature of the offense should not really matter, or its substance, or where it can be tried, because the court is not really trying the offense. The court is just ascertaining whether, on the basis of the material evidence presented before it, does those particulars constitute an offense in Kenya and in another country. The court is not concerned whether ordinarily I will try such an offense. Ordinarily, the court would have the powers to try such an offense. The court should not make that consideration. The court should only consider whether that will constitute an offense in Kenya and in a foreign country, not whether it will have the power to try such an offense. So I was explaining 2 different scenarios. Scenario whereby the matter is proceeding before a criminal court. There is possibility that the accused person may want to defeat the purpose of justice by transferring assets. There can also be scenario 2, where EACC is investigating Victor Maina for suspicion that he has acquired certain assets from a government institution or illegally, or he has certain proceeds of crime. So the EACC is still there doing the investigation, but they are not yet clear. Now, for instance, somebody can be having millions of money in the account that he cannot account for. What the EACC can do, or asset recovery agency can do, once they have information that there is money in bank A, B, C, and D, they can also apply for using a plaint. So they will file a formal plaint, because this becomes now a civil matter. and file that case before the court. But in the process, they can seek interim orders. That's why nowadays we hear orders of asset forfeiture, asset seizure, or frozen assets. So freezing means you can freeze the money in the account, bank account, so that it's not transferred, or you can freeze assets. One of the ways of freezing assets, for example, it's in a car, you can issue an order to NTSA not to transfer that car. Or the court can issue that such an asset be confiscated in the meantime. So asset recovery agents will come to your house, pick all those cars that you have earned illegally through proceeds of crime, or you have through money looted from public coffers that you cannot account for. Then they will have them in their custody. But they can only do that if they have formal orders from the court. Okay, so they will file a plaint, normal plaint, and seek interim orders of forfeiture, confiscation, seizure, non-transfer, freezing, and so forth. So that's a completely different process from a criminal trial process. That's very, very clear. Now, there are also certain circumstances where the DCI is investigating you and they suspect that you have been using your phone or mobile communication. Now, in such scenarios, the DCI will file what we call a miscellaneous application before the court to go to the bank, one, to get formal statements from the bank on your account before they make a formal charge, or in certain circumstances, they can get certain information from Safaricom. Under such circumstances, the DCI have always filed a notice of motion application now, only a notice of motion application with a supporting affidavit. But remember, the notice of motion is a miscellaneous application for purposes of obtaining only that material information that they require. Clear? Any question up to that point? Question? If no question, then we end the year there, and I wish you well in your exams. Yes, Sylvia.
Yes, I'm sorry to take you back to the first scenario that you gave us. Who is the person making the application for freezing the assets? It being a crime, is it like any normal person who has public interest in it, or is it specifically the EACC? Yeah.
Yes. So there's what we call a Proceeds of Crime and Money Laundering Act. There is also the Anti-Corruption and Economic Crimes Act. Both these statutes create agencies. One of the agencies that's created is the Ethics EACC, Ethics and Anti-Corruption Commission, with particular mandates if you read that act. Fight corruption, investigate corruption and economic crimes offenses, including ethical offenses or breach of public ethics. There's also Public Officers Ethics Act, which prescribes certain conduct for public duties. There's also the Asset Recovery Agency under the Office of the Attorney General with specific mandate. For what? You can even see from the name, asset recovery. Asset recovery in circumstances where funds and money have been stolen from the state, or you have certain proceeds, which is considered proceeds of crime. It need not necessarily come from the state. It can come from any other source. Now, more often, it is those two agencies who have always moved to court to confiscate assets, to freeze assets. I don't know whether you recall recently, there was a case of Governor Obado, who was facing two different charges, one of the offense of murder, and secondly, corruption-related charges. But at the same time, there was also the civil suit to acquire some of the properties, to confiscate or seize certain properties that he acquired illegally. That application was made by EACC. So let's just comfortably say that the person who will make the application will be either EACC, if it's an economic crime, and is a corruption offense. Asset Recovery Agency will always get involved in civil matters where they have done their investigations and they realize they have certain proceeds of crime. They will be able to move court to confiscate such assets. Clear? Dennis? So let's say EACC and Asset Recovery Agency, but the DCI can also do so where they're investigating you. Okay, no money laundering ordinarily can be prosecuted by the DCI. So the DCI can make such a formal application, in fact, or even the DPP for your information. The DPP, once the trial process commences, because they have the criminal mandate, what would be the purpose of proceeding with a trial if the proceeds of crime shall have been sold or transferred by the time a conviction is entered into? Dennis?
Thank you, Mwalimu. There was a question I was checking around, and it was a CLE question whereby one of the Kenya Defense Forces guy commits an offense here. It was a road traffic accident, and he runs away to Somalia. So what is actually your take on such a question? How can we approach it? Thank you.
Somalia, not, what by Somalia you mean, is it a Commonwealth country or a non-Commonwealth country?
Non-Commonwealth.
Yeah, that's a very good one. I don't know how many marks one can get by answering, because there has to be a formal agreement for a non-Commonwealth country. There has to be a formal agreement between Kenya and that country on that kind of procedures of extradition, deportation. There is also what they call what? Mutual. There's mutual what? The other aspect, the opposite of extradition. Mutual legal assistance. So mutual legal assistance applies, so there's extradition which applies to criminal matters. Mutual legal assistance applies in civil matters. Take for instance, somebody has illegally acquired wealth from public coffers and invested it in Dubai, which is a non-Commonwealth country, or in Seychelles, or whatever the country may be. So if you want the property to be transferred, the government of Kenya wants to take legal action against such a person, they will seek legal mutual assistance from that country under different law. Okay, Esther?
I also wanted to add on that. If there's no treaty,
sorry, Esther, yes?
Okay, if there's no treaty on extradition, they can make a formal request through diplomatic channels or consular offices or the minister of that foreign country. And then I also wanted to point us to the National Police Force Standing Order, Chapter 35, which provides for mechanisms by which a fugitive who is abroad, or let me just replace it, by which Kenya can make requisition of a fugitive who is abroad through the DCI and the Interpol. Yeah, so we should look at Chapter 5 of the National Police Service Act, the standing orders.
Okay, okay. Was that Dennis who asked the previous question about Somali Kenya Defense Force? You wanted to add something?
Yes, I was wondering whether the DPP has the mandate now to initiate the whole process in terms of actually lighting through the foreign cabinet secretary for the KDF guy to be brought back to Kenya, or what would be the best procedure, Kaidiri?
Yeah. One, you recognize that that now becomes diplomatic or international relations issues between one country and another. But then the mandate is municipal. So the DPP, of course, is the one who will commence the common criminal processes will apply in Kenya, including drafting of charges. But because the person is not here, maybe a warrant of arrest will issue, the DPP will take that, all the documentation, forward it to the Ministry of Foreign Affairs. If there is a formal agreement between Kenya and Somalia, that will be complied with. It is expected that Somalia should comply to such a formal treaty between it and Kenya. If it is not, then now it becomes a diplomatic channel issue. Actually, in both cases, whether there is a treaty or not, it's the international foreign affairs that is now supposed to take that responsibility. But the formal documentation comes from the DPP. Okay. I want to leave you there because I'm running for another meeting. If there's no other question. Yes, Minor Victor? Ask now, if I run away. Victor?
Sorry, I had a trouble with with my mic. I hope you can hear me now.
Yes.
Yes. My question is on whether you've seen instances where a fugitive has agreed to the simplified extradition procedure, where they just consent to being extradited.
Yeah, that's a funny one. Where the fugitive comment, because first of all, there must be a warrant of arrest that will, I mean, the fugitive will have surrendered to the police before the warrants are issued. I think the law is made in such a way that it contemplates an objection from the side of a fugitive, that the fugitive shall object to the issuance of the warrants of arrest. That's why there's a formal hearing process. In the event where the fugitive consents, then what the court is supposed to do, just issue the appropriate and necessary orders. I mean, typically, even in any other case where the matter is going before the court and parties really have no objection to the proceedings, the court will issue the necessary orders. Yes, Cosmos?
Yes, Mwalimu, it happens, especially where the fugitive has got dual citizenship. And he has got citizenship with the country that is the requesting country. And maybe is more likely to face the punishment would be lesser in that when tried by that country.
Yeah, I agree. That is more likely where there is the punishment that country maybe is more lenient than in Kenya. That's more likely. But again, the issue is that the court will just confirm the surrender if there's no objection. In fact, there will be no need for hearing. Once the warrant is issued, the person is brought before the court, he agrees, he surrendered. But I think the 15 days period will still have to apply. Any other?
Daktari, maybe you could throw in a few predictions for CLE.
You know, I don't set exams, neither do I mark, but JV Owiti was here before. I would be misleading. You know, I teach at the university where I set the exam, I mark the exam. So I should give the students expectations of the exam and how he'll mark or what will be in the exam. But here, I do not mark exams. I do not set exams. So I will be the wrong person to make any prediction. I would be lying to you. I would be misleading you. But ordinarily, you should be able to draft an application for habeas corpus. You should be able to draft a petition where a criminal trial process or a criminal proceeding violates the rights of a person. You should be able to draft a judicial review application. And in fact, let me dwell on judicial review application. When a question in the exams comes about judicial review application, please draft the traditional ones. A chamber summons application where you seek leave, and you can ask that such a leave act as stay. It will be before the judicial review court of the High Court, division of the High Court, and the accompanying documents, chamber summons application, statutory statement. In fact, some of the reasons why some of you fail is that they were not able to draft a proper statutory statement. A statutory statement has got the name of parties, the order sought, the grounds. So the grounds must be detailed, sufficiently detailed as possible. And so a very serious mistake. So for people who got things a mark like 11 or 12, please just know that you are not able to draft a proper petition. In a proper petition, where you are talking about violations or arguments in support of the petition, please ensure that the facts are woven into the law to make your argument demonstrate the violations under the principle of Anrita Karim in jail that have been confirmed by the High Court in the case of trusted society. You must, with particularity, highlight or outline the violations. So a petition, you must be able to draft an application for habeas corpus, an application for revision before the High Court, please. Under section 362, 364, an application for revision. You must be able to draft charges which has got joinder of persons, joinder of parties, joinder of counts, and be sure that you are able to charge a different offense per count. Don't mix offenses. The particulars should not be able to mention the particulars of another offense. Otherwise, it would be considered duplex. Okay, so you should be able to join persons in one count or join counts in one sheet, charge sheet. So you should be able to draft different charges containing different counts in one charge sheet. But you should also be able to differentiate where there are multiple parties that have committed different offense. Please identify which party has committed what offense. If in the course of robbery with violence, there are 3 parties, only 2 of them commit rape or defilement, it is only those 2 that you charge with rape, not the others, because they are not parties. See, somebody could be walking around my house, grabbing things and threatening people. While in the course of that robbery, only 2 persons go to a room and commit any sexual violation against a person, or one of them. So it will be in the same charge sheet, but now that count will only face those 2 people. So that's what we call joint of persons or joint of counts. Okay, I saw a hand somewhere. So charges, you'll be able to draft charges. You should be able to draft a petition of appeal to the High Court. And you should be able to delineate and secondly identify the grounds of appeal. So you'll get a practical scenario where the magistrate court has convicted a person, has committed certain errors here and there, overlooked the provisions of law, so forth. You identify that, and those becomes the grounds of appeal. So an application of appeal to the High Court, the person will be looking for a petition of appeal, the title, the heading, under what law, drawn by, and so forth. Inquests as well as which other one did you talk about? An application for private prosecution. An application which should be by way of a notice of motion application by the intending the complainant to the magistrate's court. The magistrate's court, it's an application by way of notice of motion application. It will be a miscellaneous application supported by the affidavit. In the affidavit, because in the when you're demonstrating the floriculture principles, the 6 of them, when you're seeking to have somebody privately prosecuted, what you need to demonstrate is those principles in the floriculture case. Have you made a complaint? Has the complaint been addressed? Has the authorities taken your complaint seriously, or they are dithering? Do you have sufficient legal interest in the matter, local standard? Have you suffered any personal harm? You know, things like that. So you should be able to demonstrate in the supporting affidavit the floriculture principles. That's all I can say for now. Any other question? It's going to be a drafting exam. So drafting the relevant applications, petition, notice of motion. Please cram how to draft a notice of motion application. Do know when you draft a miscellaneous application and a notice of motion, which is in the proceedings. Judicial review as well. An application for habeas corpus. An application for anticipatory bail and the drafting of charges. An application for appeal, sorry, a petition of appeal, or it can be a memorandum of appeal. Okay, so even a petition is an appeal to the Court of Appeal. Remember, you can only question matters of law, not facts. If it's a past appeal, you can say both erred in law and in fact. So certain words must appear in your petition. He erred in law and in fact. Or the court misdirected itself on a question of law or a question of fact. Or the court failed to appreciate point A and B, or failed to appreciate the provision of a law. So use words like erred in law, erred in law, or erred in law. The court misdirected itself. The court overlooked as provision of law. The court misdirected. The court failed to appreciate. You know, you also have to be legally smart. You have to be learned. Any other, Esther?
Is it true that you're allowed to enter the exam room with the penal code?
Anything to do with Celia, I'm not aware. During our time, we would enter with the penal code.
Okay.
Yeah. Again, also on the penal code, please, just go to the table of contents, because there are certain offenses you have never met. I remember J.V. Owiti said you focus on these offenses: robbery with violence, material offenses, stealing, handling stolen property, Look out for the offenses of rape, defilement. Those are those two. Murder in most cases. Which other did he mention? Handling stolen property, theft. You know, those common offenses. Things like AFRE. I remember during our time, there was a question on AFRE, draft charges relating to AFRE. So look out or cheating or obtaining by false pretense. Please go through the content of the penal code and familiarize yourself with the offenses, some of which you have not heard of. Again, there's a very good book by Justice Musyoka on criminal law. It defines all manner of offenses, treason, misprision of treason, all these things. Being able to differentiate between murder and manslaughter, cognate offenses, because they will be testing you on cognate offenses. That's why you'll make a determination whether to charge in the main or in the alternative, or whether to charge this as count 1 or count 2. Cognate offenses. Doreen?
Thank you, Mwalimu. Allow me to take you back to extradition briefly.
No, I want.
No, it's only one question, very brief. Let's assume this fugitive is being requisitioned by 2 countries, say maybe Nigeria and India, and I'm told to advise. How do I proceed? Yeah, and it's for a crime in both countries. How do I proceed? Thank you.
So is it not the same question we addressed? So you'll advise them, first of all, on the law of extradition. The law of extradition we have discussed. You start from section 3. You know, let's say you're an officer in the DPP's office and that person does not know the law, or you're even advising the minister. Section 3 says this is an extradition. There must be a designated Commonwealth country, and of course, India, Nigeria, a designated Commonwealth country. The principle of double criminality. Is it an extraditable offense? Yes, you'll consider whether such an offense obtains in India. Does it obtain in Nigeria? Does it obtain in Kenya? You tell them you have to consider whether it's a political offense or is sought for any other reason, racial reasons, religion, or so forth. If it is not, what else will you tell them? You're also, you're advising on the entire act now. What does the act provide? Then now you go to the procedure. Once you find it's an extraditable offense, then you go to the procedure. Now the procedure, you say, okay, fine, it is the DPP to issue the authority to proceed. The authority to proceed must be accompanied by 1, 2, 3, 4, 5, 6. It is presented before the magistrate's court. The magistrate's court will look at them, issue a warrant of arrest. Once a warrant of arrest is issued, the person is arrested and brought before the court, and the formal hearing process begins. It's called committal proceedings. It's a trial like any other, where the accused person has got rights of an arrested person, an accused person, and so forth. If the court is satisfied on all the sections of the act, then the court may issue warrant of surrender. The person is surrendered after 15 days. And now you can add there and say, but you should be able to remember the sections of the law, okay? Which I've highlighted there, section 3, 4, section 6, section 7, and section 7, section 8, 9, I think up to section 10. Section 10 is the one that provides for habeas. So you should also be able to advise on habeas corpus proceedings, okay, where somebody can challenge his on his extradition on any ground. You can even raise the question of political offense. You can raise the fact that, this offense is not really an offense in India, depending on its nomenclature. Okay?
Yeah, sure. Sorry, one more on the same. If one of the countries is a non-Commonwealth country, is there like a lesser preference to the extradite to the Commonwealth countries, or both avenues will apply at the same level?
Is there a what lesser?
I'm asking if one of the countries that's requisitioning for this person is a non-Commonwealth country, will the Commonwealth country have a higher preference, or that doesn't apply?
Not sure. I mean, the consideration would be an offense, and not the grouping of a country. I'm not sure on that.
Okay, sure.
Okay, that is all from me. I wish you all the best success in life, in the exam. I know we will interact in practice in the streets and in any other social joints. All the best. my excellent students.
Alafu mimi nakuja pupillage kwako.
Ni sawa tu, andika barua bwana. Andika tu barua.
Inafika hii kweli.
Sawa sawa.
Thank you, mwalimu. Thank you, mwalimu.
Thank you.
Thank you.
Thank you.
Thank you.
Thank you, sir.
Thank you.